Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion would be on contract of indemnity under Indian laws. And just to give you all a brief introduction about our topic, indemnity in general means a contractual agreement between two parties. And in this arrangement, there is one party that agrees to pay for the potential losses or damages that are caused by another party. So basically, when you say that you indemnify, you mean to indemnify something basically means to make good a loss. So it could be mean, it could possibly mean that one party will be compensating the other in case if it suffers some kind of losses. Now, to elaborate further and to give us a better understanding, we have with us a very special speaker. She's a warrior in the true sense of the word because she's overcome a life-threatening disease, and today she is a principal associate at Economic Law Practices. So today we have with us Ms. Megha Agarwal, and thank you so much, Mrs. Agarwal, for taking out time. Just to give you all a brief introduction about our amicus for today's session. As I said, she's a principal associate at ELP, which is Economic Law Practices based in Mumbai. She graduated from Government Law College, Mumbai back in 2013 and has been with ELP ever since. She works with the hospitality, projects, infrastructure, corporate, and commercial practices of ELP. She's been involved in various hospitality infrastructure transactions, concession agreements, bid documents, commercial agreements, etc. and etc. She's also been involved in various corporate transactions, including mergers and acquisitions and shareholder exits in her initial years at ELP. She has also worked quite extensively with the banking and finance practice at ELP. She's also authored several publications in the past decade, particularly in relation to the hospitality, infrastructure, and banking sectors. So thank you so much, Mrs. Agarwal, for taking out time. I know the weekend is right around the corner, but then to take out time on a free Friday night for a session on the virtual amicus means a lot to me and my team. Anything that you wish to say before we start with this special session?
Yeah, thank you for the introduction, Jay. And I'd just like to say thank you for having me here. I know we've been planning this for a very long time and it's always been delayed thanks to me. So I'm just glad that I could finally make it and, that we were finally recording the session.
Thank you so much. So it will be a PPT presentation. And I think the stage is set. The floor is all yours. Over to you.
Sure, thank you. I'm just going to screen my presentation. Is my screen visible?
Perfectly visible, yeah.
Okay, thank you. So right before I start, I just want to say that whatever I'm going to be saying here are my personal views and they don't necessarily reflect those of the firm that I work with. And why I chose this topic, right? Why speak about contracts of indemnity? So like you mentioned, I do a lot of commercial contracts and I've seen that in most contracts, this tends to be the sticky point for negotiations. So for young lawyers or people who are not from the legal fraternity but enter into day-to-day contracts, it'd be important to understand the concept because this comes up quite often and it's always something that neither party is willing to give up. So I think it becomes very important to just understand what the concept entails and then have a clear understanding as to what it entails. So we'll start with what is an indemnity. So under section 124 of the Contract Act, the concept has been defined and it reads as follows. A contract by which one party promises to save the other from loss caused to him by the conduct of the promisor himself or by the conduct of any other person is called a contract of indemnity. Now, the section itself provides an illustration, and it's basically that A contracts to indemnify B against the consequences of any proceeding which C may take against B in respect of a sum of rupees 200. So that's a contract of indemnity. Now, for a corporate lawyer, typically indemnities are something that are very negotiated and seen in M&A transactions. So I'd like to give an example. So say if the virtual amicus was a company and I propose to buy the share of that company from you, you'll give me reps and warranties in respect of the company, and I'll then take an indemnity from you that if there's been any breach of those reps and warranties, you will indemnify me. And how an indemnity helps, right? Why would you need an indemnity? So the first thing it would do is help manage risk between the parties and allocate potential liabilities. So say in the same example that we took, because you have been in charge of running the company, you know what you've done with it in terms of, the period before I'm going to take over the company. It helps if you can indemnify me for all past liabilities. So that risk gets allocated with you and I step into the business knowing fully well that whatever happened in the past is going to be to Jay's account, but whatever happens from the day I take over is going to be to my account. Now, coming to the second point, it also protects against third-party claims. So again, like say I'm speaking at your platform, and say you were to pay me a sum of money to like come and speak at your platform, but you say that Megha, indemnify me if you were to breach any IPR, because a third party may claim that your YouTube channel has infringed on that third party's IPR. Say I've copied this PPT from a law firm's PPT. So that's how it will protect you. If you have that indemnity, it can also protect you against those third party claims. And lastly, it may be more beneficial than a claim for damages. And I'll discuss how in a bit. We'll just discuss that in detail. So instead of, before examining how it will benefit against damages, let's first examine what damages are under Indian law. So under Section 73 of the Contract Act, the concept of damages has been covered. And I'll just read the main operative portion of it. So it says, when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by the reason of the breach. So I'm just going to stop here. So like we see, the essentials are really that there has to be a breach of contract. I should have suffered some loss as a result of that breach of contract. And this loss should be something that either naturally arose in the usual course of things, or is something that I knew would be the likely result of that. So just to give an example in terms of what this will entail, right? So say you and I enter into a contract, and I say by October 25th, I'm going to give you 5 laptops and you're going to pay me 5 lakhs rupees for it. I do not perform on October 25th, I'm nowhere to be found, and your laptops are nowhere to be found. Now, what happens is, as a result of that, you had to go and procure those laptops from the market. You were going to pay me 5 lakhs for those laptops, but in the market, you found them only for 6.5 lakhs. So, as per the construct of this section, I'd be liable to pay you that 1.5 lakhs, because that would be the loss that you suffered as a result of me not performing my part of the contract. Okay, so that hopefully helps set the context of what damages are under Indian law. And now to discuss how it is different from a claim or a damage. So under Indian law, how an indemnity is different from a claim for damages, right? So under Indian law, like we just discussed, damages are limited to what naturally arose in the usual course of things or was the likely result, right? And plus, it can't be given for any remote or indirect loss. So in the same example that I took, say I was to give you the laptops, and using those laptops, you were supposed to perform another contract with a third party. You didn't tell me about this third party contract, and because I didn't supply the laptops to you on that date at that price, you couldn't perform your contract with the third party, as a result of which you suffered a further loss. So you spend 1.5 lakhs to pay damages to that party because you couldn't supply the laptops to that party on time. Now that would be a remote loss, and that is something you may not be able to recover under Section 73 for a claim for breach of damages. But depending on how your indemnity is worded, you may be able to claim it. But I do have to say this, that it's a very standard exclusion that parties create when they're indemnifying each other. The indemnifying party will create an exclusion that they will limit their losses to only direct and foreseeable losses. So that being said, let's discuss the second one, which is in terms of claims may be made even before incurring any actual damage. Now, what is an actual damage, and what's the real difference, right? So like we saw under Section 73, you have to have suffered a loss as a result of which you'll get those damages. But depending on how you word your indemnity, you may be able to claim the indemnity even before you suffer the loss. So you don't necessarily have to go out of pocket to make that claim, as long as your liability has been incurred and it's an absolute liability. So say a court has awarded, or a court has said that the company is liable to pay XYZ amount in a tax dispute, right? So that liability, once it becomes absolute and I cannot appeal it further, etc., then you can, and even before I pay that penalty to the government, you can claim that from me, saying that, okay, make good this loss for me, and that's how it is. But again, this is something that can be diluted. Now, if I use the word make good in an indemnity, it could be read to mean that it's only actual losses because you have gone out of pocket, which is why I'm making good for it. But say, depending on how you word the indemnity, if you've not limited it to actual losses, it can go beyond that. You can tell me that I don't have to go out of pocket, you indemnify me for this. The third is the duty, that there is no duty to mitigate losses under contract of indemnity. Like we saw again in section 73, the courts do say that the means that existed for remedying the inconvenience will be something courts will take into account while awarding damages. But again, in a contract of indemnity, unless the contract so provides, there's no explicit duty under Indian law. The fourth difference would be that the trigger may not necessarily be a breach of contract. So I shouldn't, depending on what you have indemnified for, say in the M&A transaction where I'm purchasing the shares of virtual amicus, if you indemnified me for a specific indemnity event, say there's a tax claim, which is, going on in a court and it's going to materialize into something. If you've indemnified me for that you wouldn't have breached your contract for me to have claimed that indemnity, but that's a specific indemnity event that you agreed to indemnify me for, so I'll get that right. And lastly, it's not impacted by knowledge of an indemnified party. So what this really means is that even if I was aware that, say, the representations you gave me were incorrect or inaccurate, depending on how the contract is, and there's a concept called sandbagging and anti-sandbagging, which I'll deal with later in the presentation. You again, like I said, it depends on how you word the contract, but it's not barred because that concept's not there. Now, moving on to what are the rights of an indemnified party. So section 125 of the Indian Contract Act lists down what the rights of an indemnifying party are. And they basically say that the indemnified party can recover three types of costs from the indemnifying party. The first being damages that the party had to pay. Second being any costs that the party had to pay in respect of any suit and defending that suit. And there are some carve-outs that are listed out that you basically have to not violate any orders that the indemnified party had made, or that you don't have to, or is something that you've been authorized to do, etc. Three is again any sums that they may have paid under the terms of any compromise of such suit again, and the same principles that are therefore to apply for three as well, that you don't contravene the orders, or it's something that you've been authorized to bring or defend the suit. Now that we've discussed what an indemnity is and what the rights of a party are, let's come to what are the safeguards of an indemnifying party. So before I start getting into the safeguards, see, like I said, indemnities are something that come up day to day in every kind of contract. If it's not a high risk contract or a very significant value contract, the safeguards listed down in the first row should be enough to take care of you. And obviously, if it's a high risk, if it's an M&A transaction, etc., you can then look to the safeguards from the second row onwards. So let's deal with the first row, which is the basic safeguards that you can have in place if you're giving an indemnity. The first is, because these are safeguards from an indemnifying party's perspective. So say if you want to flip it and think that what should an indemnified party look to, you obviously like flip all of this and think of the converse situations. But I'm speaking from an indemnifying party's perspective. So first being, limit it to actual losses. We discussed what actual losses are in the previous slides. So you can have language to say that you'll make good or you'll compensate. So then basically it gets limited to actual losses and not just that other party would have to suffer those losses for you to be able to pay them. The second being a cap on liability. The way what this essentially entails is that you put in a monetary cap in the contract to say that I'll never be liable to pay more than this amount. It could either be, so say if it's a service agreement, right? So you could say that it's 100% of the fee under that agreement, or it could be a lesser percentage of the fee. It could be 25% of the fee. So depending on the nature of the contract and the commercial understanding between the parties, you can arrive at a cap. Why this helps is that it doesn't leave your liability open-ended. You know how much potential exposure you may have if something was to go wrong. Something was to go wrong being the indemnity events were to kick in. So, which is why I think it's always essential to have a cap on your liability. Three is the waiver for consequential damages. So as again, we discussed how while under breach of contract, damages are awarded only for not awarded for indirect or remote losses, but for indemnity, since the law itself doesn't have it, it's advisable to have a waiver for consequential damages. Again, it's a debatable position that if you were to not have this, would courts award consequential damages or not, is something that we have to consider separately. But from a indemnifying party's perspective, it is a pretty standard ask to have consequential damages mentioned. The fourth being a time limitation for claims. So depending on the nature of contract, you may want to have a time limitation for claims. You could say that for my indemnification obligation to will subsist only for a period of 1 year from the date of termination. If it's a high value contract, like if it's an M&A transaction, because if I'm buying shares from you, my fundamental warranties in terms of the fact that you have title usually subsist for a longer period of time. So my right to claim that indemnity is also something that people like to have in perpetuity. But say if you'd indemnified me in respect of tax related claims, we could limit it to 7 years and stuff like that. And for other business related warranties, you could claim an indemnification obligation for a lesser period of time. So depending on really what the commercial arrangement is and what you're giving the indemnity for, you can also structure this. Obviously, in the absence of a contractual limitation in terms of time, the statutory period of limitations would continue to apply, and there's no way that you can run rogue from that. But this helps in just limiting your liability further, right? You can just say 1 year and reduce it. Now, coming to the additional safeguards, if, like I said, it's a higher risk contract. So again, say like in an M&A transaction, like I said, the standard indemnity is really seen for breach of reps and warranties. So if you were to provide disclosures in terms of your reps and warranties, that really helps again mitigate your liability, because if you've disclosed something, then the risk of that rep or misrepresent rep or warranty being incorrect is that much lesser, because you know that while you're saying that there are no litigations, but you've disclosed 2-3 cases that you're aware of, so that helps you limit your liability again. Then the second thing is a de minimis threshold. It's basically one is a cap on liability that I'm not going to be liable beyond that, but a de minimis threshold is basically something you say that I'm not going to be liable for something of a small value. So say if in our laptop example, the contract value was 5 lakhs. Now, if because of some small act of mine, the damage occurred, because of which you had to spend like 4,000 rupees to just rectify, like maybe get a cardboard box because I failed to supply that as part of my contract. That's a very small amount. So we can contractually say that if it's a small amount, or if it's anything below 5,000, I'm not going to indemnify you. If it's anything above 5,000, only then I indemnify you. There's also other concepts like a tipping basket, etc., but I won't get into too much details. But this is the idea that you can create monetary thresholds. One is a upper threshold beyond which you won't be liable, but there's also something called a de minimis threshold that you won't be liable for something as minimal as that. Now, in terms of the anti-sandbagging provision, this is something I discussed earlier as well. So if you knew that a representation was incorrect while entering into the document, right? A provision like this will help you in the fact that that other party cannot claim an indemnity from you for that, because they had the knowledge that the rep you were giving was incorrect. So this provision will help that. So again, depending on the party you're acting for, there's also something called a sandbagging provision, where you say that despite my knowledge, I would be able to claim this. So that's something that can work both ways depending on how you draft it. The next point is on recovery only once for the same loss. So this is just to clarify that you don't dip into like 2 baskets for the same, that you don't claim damages for me under breach of contract and claim the indemnity for the same thing. You recover once and you choose what you want to pick up. Now, in terms of again, the indemnified party's obligation, we saw what the rights under 124 were. So which is why notice of claim becomes very important, that you give me a notice within a specified time. So say if I've indemnified you and you have to call upon me to basically say that this is the claim I'm making, this is the basis for making my claim. And that kind of helps decide whether or not that claim falls within the scope of the indemnity, etc. So which is why the notice of claim becomes very important from an indemnifying party's perspective. And the other point that's kind of tied in with the notice is also controlling the defense of the claim. Because the indemnifying party is really the one that's going to bear all costs, right? They would have indemnified for that claim. It becomes important for them to control the defense, because then they see as to how much potential costs they're going to incur, right? In terms of who they're appointing as advocates, or at what stage do they choose that a settlement may be more worth it, or do they keep contesting the litigation in whatever fora it is at. Obviously, from the indemnified party's perspective, also it is important to have some sort of control, but usually, they get approval rights before you settle, etc. But usually, from an indemnifying party's perspective, this would serve well if they have get the control of the defense. And lastly, duty to mitigate losses. From an indemnifying party's perspective, you should prescribed for such a duty on the indemnified party. Like we saw under 73, there is something, the courts will take into account if there was a means to remedy the inconvenience. But the section on indemnity doesn't specifically have that, so which is why it becomes important to also have this in contractually. So it kind of again limits the scope of your indemnity further. So this was it from me.
So thank you so much there, Ms. Agarwal. This really very insightful session. There is one standard question that keeps popping up. So obviously you discussed everything in detail wonderfully, from what indemnified party means and where is it defined, the contract of indemnity, to the safeguards, to everything. But the basic difference between contract of guarantee and contract of indemnity. Now, if you could in a nutshell differentiate between the two, because this is something that keeps popping up every now and then.
Sure. So in a contract of guarantee, and I'll take the perfect example of a bank guarantee, right? So I have a project, I bid for a project, and they say that you get me a bank guarantee against the, earnest money. I have, say I owe a loan to you, and I get a bank to guarantee my obligations, to say that if I fail to repay 5 lakhs to Jay, the bank will step in. And that's really how the guarantee works, right? That the obligation is something that I owe to Jay, but whether even if I fail to meet it, the bank you can always go, if I give you a bank guarantee in your favor, the bank will step in and make good, and pay that amount to you. But in terms of an indemnity, it's something that I am promising you to save from a conduct of either myself or any other party. So that's how, like we discussed a couple of examples, so that's how it'll be different.
Perfect there. So I think it was a very insightful session, and I'm sure this session will immensely benefit all the viewers, because this is one really very important section in Indian Contract Act that every law student studies, at some point of his or her law school career. So thank you so much, Ms. Agarwal, once again for taking out time. And this session really means a lot to all of us. Your journey, your story has been extraordinarily inspirational to everybody. And so stay tuned, everybody. Next episode is on its way. Stay home, stay indoors. COVID is still around. And anything that you wish to say towards the end of our segment before we wrap up?
No, I just want to thank you for having me here. And I think what you're doing with the channel is great. It's a great platform to share knowledge as young lawyers. And also, I think we were discussing before, it's great to even get to know what all your batchmates and peers are doing, right? Because we connected thanks to this after 9 years of being out of college. And I think otherwise also I keep following the channel and I keep seeing people who are coming. It gives a good idea as to what everyone's up to, and then if you need that expertise in that area of law, it's good to reach out to those people as well. So I think what you're doing is really great.
Thank you so much there, Ms. Agarwal. The kind words coming in really mean a lot to me and my entire team. And I must say that though we never connected in college, but it took a channel, a YouTube channel, to reconnect with all your previous contacts. So thank you so much once again. Really means a lot, your presence. And this session, of course, that will immensely benefit all the viewers who are watching this, be it law students, being young lawyers, be seasoned advocates, because there's one very important provision in the Indian Contract Act. We hope to see you soon on another subject. So thank you so much. It's goodbye for now.
Thank you so much.